Hey guys, welcome to Probate Café. My name is Eric Kaiser. I'm your host. And today I have with me here is Weily Yang, and he is an estate planning attorney here in Orange County, California. So Weily, introduce yourself. Tell us a little bit about yourself.
All right. Well, thank you, Eric, for having me. My name is Weily Yang. I'm with Mortensen Reinheimer PC. We are located in Irvine. We're primarily an estate trust and estates law firm. I handle primarily special needs trusts and conservatorships, but that's why I'm here. I'm also doing probates and really trust and estates across the board.
Fantastic. Tell us a little bit about probate.
Well, probate is something you do not want. It's a court-monitored procedure. In other words, it is where the court appoints a personal representative to administer the estate. The estate is in the person who had passed away. We'll call it the decedent. If the decedent died and had a house, cars, bank accounts, those will have to be probated. In other words, the personal representative would have to marshal the assets and then go do the process and then really get them distributed to the beneficiaries. If the personal representative is the beneficiary, then he'll take it all for himself.
Interesting. Okay. Now, I heard you use a term that, what does marshaling the assets mean?
Good question. As I said that, I was thinking maybe I should define it. Marshaling is basically taking control of the assets. So, for example, a bank account. At first it's titled in the name of the decedent. When you marshal the assets, the personal representative would take hold of the account and then put it into an estate account. So it becomes the probate estates account. So it'd be titled in the name of the estate.
Oh, interesting. Okay, yeah. There's a lot of terms that even I don't know.
Yeah.
So attorneys use a lot of verbiage that sometimes we don't just cross. So
we try to sound smart.
Well, I'm sure you are. Hey guys, just want to take a quick break. If you like what you're seeing and what you're hearing, please feel free to like, comment, and or share this video wherever you see it posted. Would really appreciate it. Thanks for watching. All right, so tell us, is there any ways that someone can avoid probate or bypass probate, I should say, and basically how can that be done?
Yes, the number one way to bypass probate is to establish a trust. Now, what is a trust? Think of it as a will. But really, again, it basically avoids probate.
Okay.
And of course, you can imagine there are different types of trusts, but the one that I always recommend is a revocable living trust. So back to your initial question, a trust bypasses probate. There are other ways, like if the decedent's estate is below a certain threshold. I believe now it is 185,600. I should know this, but I can't for the life of me remember that right now. But if the estate is below that threshold, you can get by with a small estate affidavit. So again, that's another way to bypass probate. I'll say one more. There's another alternative or another way to bypass probate, which is a spousal property petition. So that is where the spouse basically tells the court that, hey, everything is community property. There's another key term there. Everything is community property, therefore I should get the decedent's share. Now, what's community property? Well, we live in a community property jurisdiction here in California. So presumptively, once you're married, everything is owned 50-50 between the spouses.
Interesting. Okay. Wow. That makes you think about a lot of different things right there with that statement.
Yep. As I was talking, I kept thinking to myself, wow, there's another key term, there's another key term, there's another key term.
Yeah. And obviously there's different types of trusts out there as well for depending on what the needs are. For example, you handle special needs trusts as well, correct?
Yes.
What is that? Like what would somebody need that for? In what situation?
Primarily to preserve government benefits. To be specific, it would be needs-based benefits like supplemental security income or SSI or Medi-Cal or in-home services or IHSS. So if an individual receives any of those government benefits, um, I highly recommend that the individual who has the special needs get a special needs trust. That way, the government benefits are preserved.
Interesting. Okay, yeah, because I know there's differences, and I guess every situation is a little bit different. That's why I guess someone should call you and kind of you can walk them through that process when you possibly meet with them or
Oh,
speak with them,
definitely.
right? Because there's everybody's situation is going to be different.
Definitely. Part of my goal, and this may sound campy, is that I just want to spread the word to the special needs community that there are resources out there for families, such as a special needs trust. And another one is conservatorships, specifically limited conservatorships.
Okay, so that basically helps the family basically not go broke if they're getting some sort of government assistance or they need maybe medical care. Is that kind of how that works?
Not necessarily. It would be more if back to the individual with a disability, if he or she is receiving government benefits, and let's say there are other assets that he or she may own, whether it's a bank account, there is a threshold. The resource limit is 2,000. So if the disabled individual has 2,000 or more in resources, um, the Social Security Administration or the company that provides the government benefits, they may penalize the disabled individual, thereby diminishing their government benefits. So by having a special needs trust, the disabled individual would be able to receive both assets outside of government benefits and the government benefits themselves.
Okay, interesting. Well, share a little bit about probate and the process. You know, if someone has to go through that process, what does that look like?
Ooh, good question. So it's a very rigorous, well, rigorous is the wrong word. It's a very long winded process. If you were to file a probate petition with the court today, I'd say it'd be done, it'd be complete in about a year and a half.
Really?
It's very long winded. Not only that, highly recommend that the individual seek an attorney. And I'm not just saying that because I'm one myself. Even courts recommend that the individual seek an attorney because really there's just lots of paperwork. It is court monitored, but the court is very limited on what they can help you with. They can't provide legal advice. There are a lot of things to consider as well during the probate process. There's a lot of parties you deal with, whether it's the bond company, the probate referee, which is the person who appraises decedent's assets, and if there are beneficiaries who are represented by an attorney, well, unfortunately, the personal representative will need to work with that attorney as well. So by having an attorney, a probate attorney per se, at the very least, he or she will know what to do, who to speak with, what to say, and maybe sometimes what not to say. And that way, it'd be a much smoother process.
Sure, yeah. And I know that there's some attorneys out there will take on any case, and I've seen that. So they don't really specialize, so they may not know those small things of what to or how to put the package together, I guess, for the courts. So it could definitely cause some issues, right? And
Oh,
expose I guess the decedent or the estate to different things out there that privacy regarding privacy, things like that. I mean, probably could be a lot of different things, but I'm sure you want to deal with someone who specializes, not just any attorney that may, for example, do personal injury, right? That may come across a probate. Somebody calls them up and says, "Oh, we need to have this probated. Can you help us?" And they say yes, and they got to research it, and then they have to. I don't know if the right word is, work with possibly another attorney. I don't know if that's what they call possibly, I don't know if that's co-counsel or if that's, I don't know if the terminology, but does that happen where they have to bring something, or typically they'll refer it, but does it happen where someone like that, that is a personal injury attorney or a divorce attorney have to contact someone else, and do they work on the file together, or do they just kind of refer it on to somebody more qualified? How does that work?
yeah. I mean, I recommend that if a personal injury attorney, if he or she doesn't know or not familiar with the probate process, they refer the client to a probate referee. I mean, there's really no point in this personal injury attorney sticking around. I mean, because he or she will not know the process, what paperwork to do. It's better if they just basically transfer the retainer or just cut ties, in other words. So
Gotcha.
the personal injury would just refer to a probate referee, I don't know why I keep saying probate referee, but a probate attorney, and then be done with it. Now, they can be co-counsel, a personal injury attorney and a probate attorney. They can work together, but I just don't see the benefit in that. Well, I mean, there'd be a benefit to the personal injury attorney because he would still get paid in the end. Sure. But the probate attorney would be doing all the work.
Yeah.
So it just doesn't seem efficient, and it just doesn't seem right, really. But yeah, you could do co-counsel if you wanted to.
Interesting. Yeah, it makes you think of different things of what to look out for. That's why I always try to ask these different questions of, what can somebody, look out for to put themselves in the best position to make sure they're going with the right person for the right reason.
Personally, if that happened to me, if a personal injury attorney approached me and let's say has a probate case, wants me to step in, and if I get the notion that he wants to stay retained with this client, I probably ask him very kindly, like, in other words, like, why are you, I mean, let's just end your representation here, and then I could step in. Otherwise it can get a little awkward.
Oh, for sure. And then it gets muddy, and
muddy.
Everybody's time gets a little bit, it's wasted because you got to go. It could be a nightmare.
Not only that, I would have to, because I mean, if the probate attorney is the one that's doing all the work, and if there's co-counsel, he would constantly need to seek that personal injury attorney's approval.
Sure.
And 9 times out of 10, that attorney's just going to say yes because he or she doesn't know anything. And I'm not criticizing or belittling personal injury attorneys.
Right, just different fields, right?
Right.
Like you don't go to I said it before, a heart surgeon for brain surgery, right? It's just that you just don't do it.
No, they can try to wing it, but no, that'd be disastrous.
Wait, does probate have any benefits? And if so, what would they be?
Even though there's a lot of cons to this, probate could be a good thing. One, it becomes publicized. You hear all these celebrities who had passed away, and like for Prince, for example, he didn't have a will or a trust, I believe. So it was publicized. Yes, there was a lot of scrutiny. Yes, there was a lot of criticism. But I mean, hey, at the very least, everyone's kind of watching it. More importantly, the courts. So you can't really pull any fast ones, not saying anyone would. Mm-hmm. So in a way, it becomes a public record, so you can't really dispute that. For example, if there was a will, and let me back up here a little bit. In California, even if you have a will, it still has to go through probate, unlike a trust. But it could still be a good thing because once you lodge or file the will with the court, which you have to do, the court keeps the original. Then, moving forward, no one can come in and object and say there was no will because guess what? There is a will. Of course, that person could dispute it, but hey, the will's there. So it could be a good thing, and then if the will is valid and the court accepts it and the will becomes, validated, mm-hmm. whatever that will says must be followed. So in other words, whoever was named as the executor, which is the personal representative, the person that administers the estate, well, no one else can come in and say, wait, I should be the executor because, well, the will itself says, for example, Sam is the first executor, not the person who's disputing it. So it could be a good thing. Yeah. So there, in other words, there's evidence,
Gotcha.
and it confirms what the person who passed wanted. In terms of how distribution should be made, who should take control, and what have you.
Now, I know you said the will must be filed with, or would be filed with the courts, but is that will then accessible to anyone? Is it a public record then?
Yes.
Really? So someone's private remarks in a will can be public record if they don't have a trust, basically.
Right.
Okay, so everyone listening, if you have a will and there's some personal information in there that you don't want shared, especially if you're possibly a celebrity, reach out to Weily. He'll make sure that he takes care of you because you probably don't want that information out there as a public record because then anybody can have access to it and somebody will turn it into a story.
And kind of switching things around, we were kind of mentioning the benefits of a trust. And again, trust is great because the number one benefit is bypassing a probate. But here, just to kind of flip it around, a trust is a private record. You don't have to file that with the court. So that's one of the cons to a trust. If someone had a trust, passes away, and let's say the person who created the trust, we'll call him the trustor. If the trustor didn't have a trust, but let's say gave a copy to his brother, and and let's say the brother for whatever reason doesn't want the trust to be processed, doesn't want to be administered, and so the brother just tosses it or just destroys it. It's a private record. You can't really prove it, unfortunately.
Yeah.
So that is a huge downfall to a trust. So there are pros and cons to both a will and a trust.
And there should be there be copies of a trust.
Oh yeah,
I mean, the attorney will have a copy, or
yes.
Okay.
Really, I recommend the trustor, again, the person who prepared the trust. He or she should give a copy of the trust to the first person he or she named as the successor trustee. And then if there was a second successor trustee, I would give a copy to that as well. Now, the successor trustees, real quickly, it's the person who administers the trust once the trustor passes away. Because during the trustor's lifetime, the trustor is still the trustee until he or she becomes incapacitated or passes away. So I just want to distinguish trustee and successor trustee. But again, going back to the successor trustees, as long as they have a copy of the trust, and let's say there was no bad blood and the bridge hasn't been burned down yet, once the trustor passes away, the successor trustee's got a copy of the trust, can immediately start the administration process.
Oh, okay, interesting. Yeah, learn something new every day. It's kind of interesting because a lot of the times where I'll assist attorneys liquidate and sell the estate property. That's basically what I do. The new buyers, and typically buyers that I've worked with in the marketplace, and from everyone else I've spoken to, whether they're realtors, lenders, only about 80%, well, actually I said only about 20% have a trust set up. Mm-hmm. So there's 80% of the people out there that just don't have a clue.
Yeah.
And it's just like, it's going to happen, right? We don't live forever. So we don't know when that day comes. It could come sooner or later. But if you just buy a house and your next stage should be, and if you're married and you have a family, I think your next step should be, obtaining your life insurance. If that's the case, if you have small kids, right, you get your term life insurance for, 20 years or whatever, and set up your whole life maybe, and then get your disability insurance and all that lined up so you can protect your family. But also, setting up your trust. That's going to be really important. But people always forget that. They'll get to maybe the life insurance aspect of it, and it'll stop there. And it's just, you see it, and you could pull public records of a neighborhood, and you just look at the title from everybody that's in the neighborhood, and you're going to see probably only 20% of those homes are in a trust. Unless, people that live to a certain age, for example, 65, 70, that's where you'll see a lot more of that. Because usually the kids will push them in to get it because they don't think of it when they're younger.
Right.
Problem comes up is when a lot of my clients, they pass away when they're younger. So that's the problem and their younger kids lose out because, probate can be expensive as well. And it just ends up, becoming a nightmare and a mess for everybody to go through. But I definitely think the trust is the way to go, for example. And, just having that done is I think is a big help. But so when someone sets up a trust, but we also don't we still have a will as well? So why would we have a will if we're also setting up a trust, or would we just have a will?
So when you think of a trust, it actually includes what we call a pour-over will. And a pour-over will acts as a safety net to the trust. What that means is when you see a pour-over will, it'll have the trustor, the person who created the trust, it'll have his intent, that basically saying that whatever he or she may own that's not included in the trust, well, their intent is to put it into the trust. So again, it acts as a safety net to the trust. God forbid, let's say the trust goes missing or it's destroyed for whatever reason, you can still lodge that pour-over will at the very least. So at least you'll have instructions there on what the trustor wanted, whether it's the executor in this case, which is like the trustee, but executor is the person who manages the will in the will. So,
Okay.
and I know I'm throwing a lot of terms. So we got the personal representative, we got the administrator, we got the trustee, and we got the executor. But they all have basically pretty much the same duties here, or
Okay.
fiduciary duties.
Interesting. And then opening up a probate, what does that cost or entail?
It depends on the amount of the decedent's estate.
Oh.
The bigger it is, the more fees that they may that there may be. For example, if you were to hire an attorney, their fee would be higher. Now, caveat here: us attorneys, we don't get paid by the hour in probate. We actually get paid statutory. What that means is under the probate code, there's a formula, and we get a percentage of the estate. So you can imagine, the bigger the estate, the bigger the statutory fee. So another reason not to have probate, really, by having a trust. Now, of course, we'd be more than willing to help anyone who's going through probate, but we always warn them that, hey, so these are the expected fees. Here is the statutory fee. If anything falls outside of the probate process, the best example would be if it has to be litigated for whatever reason, then it would be what we call an extraordinary fee, which would fall outside of the statutory fee. And at my firm, we work on an hourly basis. So whatever litigation we have to do, it would be by our hourly rates. So again, you can imagine the cost. So at the end of the probate process, not only will we be seeking statutory fees, we'll also be seeking extraordinary fees.
Sure, yeah. Just nobody works for free.
No, but a lot of people think we do.
Yeah, yeah. They think we all do the same thing, and it's so easy. That's probably why we do see pro per filings where someone would be filing a probate, on their own behalf, right? They want to administrate. They want to be the administrator, so they're petitioning the probate courts, right? I don't know if that's the correct terminology for the position of administrator or executor, because they want to save that money. They think it's they're going to save this or that, but they don't realize it takes them forever. And then if there's multiple beneficiaries that are leaning on them to move forward because they're not sure how to do something or they don't have the time, energy, or effort, depending, and then those other beneficiaries could hire an attorney, and then they'll probably have to hire an attorney anyway to just kind of deal with them, especially if they're distant relatives or they're not on good terms. It just becomes a nightmare. So it's I think definitely having the attorney is a benefit. If you don't want to drive yourself crazy trying to do probate or go through probate with multiple beneficiaries that may get along, right? Because eventually everyone wants their money. Once they're going to say, okay, well, where's our money? They're going to think they're not going to know, right? It's going to take a year and a half, regardless. And then they're breathing down the neck of the administrator, a year down the road, where's our money? And that's typically what I've seen happen is then they actually hire the attorney. So it's just kind of interesting, the stuff that I've come across, and why I think it's important to have an attorney. There's a lot of things that it's not just the money, it's the headaches, the stress, everything that comes along from the beneficiaries, right? You're a good buffer zone to say, okay, yeah, we're working on it. It's going this direction. This is just what it does and how long it takes. So they're not, jumping on the administrator and just, bad blood building up, right, for the family.
Right.
So that's kind of interesting.
And not only that, by seeking a probate attorney, hopefully he or she will also know the court rules, the local rules, and when I mean local rules, like Orange County and Los Angeles, they have their own local rules to follow, and a person who comes in pro per and doesn't have an attorney. Now, mind you, it's definitely possible to do a probate without an attorney. There may be some hurdles to overcome, and one of them would be local rules, unless it's someone who's familiar with the court system, familiar with that specific court. Someone coming in pro per may not know it, and it'll just get continued and continued until, like you said, a beneficiary may start to wonder what is going on, what's taking so long. You haven't even been officially appointed yet. It may stir up some trouble and some angst, and then, yeah, but I mean, like you said, in the end, beneficiaries, they just want their money. And yeah, I mean, the person who's trying to get appointed, it's their job to administer the estate and get the distributions to the beneficiaries. But beneficiaries, yeah, there are the pushy ones, and then there are the patient ones. Especially the pushy ones. I mean, really, we try to tell them all the time that we're just trying to fulfill the decedent's last wishes, and also do what he or she, or not do it, but provide for the beneficiaries in the end. So in other words, again, just wanting to dot our I's, cross our T's, and do what's necessary and do what's required.
Sure, and then that's part of our job is we do the best for everyone, right? The estate is all the beneficiaries. And I'm in a situation like that right now where the administrators, there's emotional attachments to the property. They're not acting. The beneficiaries had to hire a different attorney to basically have this administrator removed because they're not acting. Right. They're not doing anything, and it's been years. So in that case, then the family dynamics change at that point at the family reunion. Yeah. But people are only going to wait so long because everybody's going to, everybody wants their money. It's just the way it is. Yeah. But you do run into those problems. So if you're in that situation and you're out there listening to this and you're in pro per, I guess, and you're running into those situations where you have beneficiaries breathing down your neck and you're not sure of the direction, definitely reach out to Weily. He can definitely help you because I've seen it and it's not fun to go through that process, and you see it with the beneficiaries, and it just doesn't turn out well for anyone, and it's not a good thing to go through, and people don't realize until they're there. Right. And you've got out-of-state beneficiaries, with someone locally trying to handle it, and they don't know what they're doing. They're not acting. They want to hold on to this. They're dragging their feet, and it just becomes a real hurdle to keep that process going. Mm-hmm. And then it could be 3, 4, 5 years. I mean, the beneficiaries could pass away before they get their inheritance, right?
Which has happened. Yep.
So
and then we have to deal with their estate, and that's another ball of wax. Yeah.
So a probate, two probates basically at that point.
Yeah,
could be.
Yeah. Hopefully that beneficiary has a trust.
Then hopefully it would work out.
Right.
But that's the thing. Every situation is different, right? And speaking of that, tell us, do you have any kind of horror stories where something that jumped out at you that a client or someone that could have done differently, whether it's probate or setting up a trust? Is there anything that people should consider if they're listening to this out of the area and they're going to go see an estate planning attorney? Is there something? I know the biggest one that I see is typically if somebody puts 2 trustees on the trust and they may or may not get along, right? Yeah. That's typically what I see. But what do you kind of see that people should really look out for or consider when setting up a trust or going through probate?
You just took my example, because I was going to say I don't recommend having more than one personal representative, whether that's the administrator or the executor. That way that one person doesn't really have to speak with the other or make decisions with the other and make up their minds, what have you. Just dealing with one individual. A great horror story was we had a brother and a sister come to us. Unfortunately, their mother, it was a strained relationship. They had no idea their mother had passed, and they found their mother like 2 months later in her apartment. So you can imagine how morbid and just it wasn't good. Yeah. So we tried to convince them because at the time it was just the two of them. They were the sole heirs, and there was no one else. So one or the other would have to come in and administer the estate. Well, they both wanted to administer, but we tried to convince them, let's just have one. Not only that, one of them lived out of state, but they both insisted on being co-administrators. Okay, fine. So we got them appointed. Sure enough, one of the administrators had a family law issue, In other words, was seeking they were trying to get child support from him. So he immediately wanted the other administrator to take over. Well, it's like, well, we can't do that now. You're appointed. So needless to say, the family law case was kind of following the probate case. It was a nightmare.
Oh yeah.
It was a nightmare. And I believe that case is still going because in the end we had to drop out. We got the probate pretty much wrapped up, but due to some of the difficulties, we had to substitute out.
Yeah, it's very interesting that you say that, and you bring up the different administrators. I've been doing this for a while. I probably assisted over 100 estates sell the estate home. I've run into situations where I've had two administrators on the probate estate. So, both of them have to agree, and, we have to get everything signed. But I'm in a current situation where it's a condo, and it's under $2 million in LA. It's a big value.
Okay.
There are three administrators.
Oh boy.
And two of the ones are out of state, and the other one is out of the county. So it's just kind of interesting, and I don't know how well they all get along.
Right.
And then now we're going to renovate the property because typically it's going to be in the best interest of the estate. Paint, carpet, small renovations like that,
Right.
just to spruce it up a little bit before we go active on the market. And now everyone's got to basically approve that. And they've got to sign all the paperwork, and you've got to educate people and why you're doing something, and some may agree, some not. But if one doesn't and say no, we'll just go as is, then it's definitely going to cause it to take a lot longer.
Oh yeah.
For people to come around and really understand. It just makes it challenging because basically we're investing part of their inheritance as well in these renovations, right? So if,
Right.
a lot of times you'll get someone that doesn't really understand it. And someone that does and sees that it can happen and stall things. So this one is going to be an interesting one with three administrators. That'll be my max, and it falls in line with the one probate that I had with. I think I had a total of 6 beneficiaries all around the country,
Okay.
and two of them knew more than I did, so to speak, right? So and then it was interesting. So you run into they're all different, and you got to work with everybody in different phases of whatever they're going through because everybody's going through it differently, right?
Now those three administrators, do they each have their own attorney?
The two have there's two attorneys, yes. So
Okay.
there's the two of the attorneys. Or two of the administrators that want to work with me have one attorney
Okay.
that I work with. The other one has their own attorney, and actually it was kind of interesting. They wanted to try to use their realtor, but he is a commercial real estate agent. So
Okay.
I'm like, that doesn't really work in residential.
Right.
And then when you're dealing in probate sales, there's a lot of things to look out for. People think you just sell it for, no, there's occupants issues.
Right.
There's selling as is, you knowing your costs to renovate. How are you going to work with the investors? You're negotiating investor profit margin.
All right.
Otherwise, you end up a victim, like on these HGTV shows as house flippers, right?
Yeah.
Well, the estate's the victim that they bought the house from
Yeah.
so cheap. And that's, kind of my job is not to let that happen. But
There's a red flag right there, right? There's two attorneys involved. So it's already a red flag.
Oh yeah. Yeah. It's kind of funny. And when the attorneys argue, sometimes they'll include us on the emails, which we don't really need to be in because our job is very specific over here. But it's just kind of funny when I do see
Wonder
the
why
attorneys.
they CC'd you, and it's like, oh, okay, this is, why did I take this case?
Yeah, that's what, and it's like, hey, will you do? Okay, yeah, we can do this. And I've been involved with one of those. I'm like, I don't, thanks for sharing, but I'll just do this over here. You guys do your thing, and I'll handle my thing.
Because they like you that much, Eric.
I guess so. Yeah. But they don't need to like me that much because I don't need to see all those. And share with us a little bit about the process as far as the time frame. How long does the process take typically, and how long could it take if they don't have an attorney?
Well, I mean, as I said earlier, it takes about a year and a half to go through the entire probate process. Pre-pandemic, it was about a year. Pandemic, it was like 2 years. It got really bad, and You can imagine courts were closed. People were isolating themselves. They were hard to get a hold of.
Sure.
Now with the pandemic pretty much gone, I guess it's like a year and a half. The courts are catching up. Actually, we're all trying to catch up here, and we're getting like a slew of new cases, not just probates. Just cases of all angles here. But to your second question, is someone who does not have an attorney. I mean, it can go on for a while, unfortunately.
Yeah.
I mean, it's that you just don't want the case to, or you just don't want the hearing to get continued, or what we say, it gets kicked. So, for example, if the personal representative filed the necessary paperwork to get appointed, and let's say at the hearing, the judge says, unfortunately, there are probate notes, and probate notes are questions from the court that you can find on the court's website. They're usually like clarification or additional information needed from the court, and then the court will say, well, because you have probate notes, it'll get continued 2 months out. Well, then there goes 2 months. So while you're trying to answer the probate notes, then at the next continued hearing, and let's say the response you made or the personal representative's response wasn't sufficient. They need more information, or maybe perhaps the person's response warranted or generated additional questions. Well, the court's going to continue that again another 2 months. So that's 4 months right there.
Wow.
So you can imagine it just kind of snowballs.
Sure.
And it doesn't happen with all cases, but from my experience, when I'm in court waiting for my case to be heard, and I see or I hear individuals in pro per coming in, 9 times out of 10, you'll hear the judge say, hey, did you see the probate notes? Do you know how to answer them? Do you know what probate notes are? Well, we're going to continue it till 2 months out, and they don't have a choice.
Oh, wow.
And not saying attorneys are perfect either. Sometimes attorneys need time to clear probate notes. Sometimes the court will continue the probate case, even if there's an attorney. That it makes sense. But someone who comes in pro per, it tends to get continued a lot. And I'm not trying to criticize individuals.
Sure.
It's just, the court wants a response a certain way, or is seeking certain specific information that perhaps the individual does not know how to present it. So,
okay. And now in Orange County, where you practice, there's 3 or 4 judges, probate judges. Is that about right?
Let's see. 1, 2, 3. I believe there's 5 or 6 now.
5 or 6.
Two are about to retire.
Okay.
And I want to say 5 or 6.
So
I should know this.
Well, I'm sure you've been in front of these judges
Yes.
enough times. You know how to answer the questions of what they're going to be asked, right? In the probate notes,
Yes.
I would imagine, right? Because they're all going to be a little different. So if you know this judge is going to ask it this way, they want a detailed response for this, and this
Right.
judge is this. So that helps also to work with an attorney that actually works in the field of estate planning and it actually goes to probate court quite often, because you'll have that inside track to speed that up. Right?
Exactly. Yeah.
Okay. Yeah, that's interesting. And time is always a factor, because I mean that's
Always
the only thing
is. Yeah.
we can't get back. And I always share with people, if you're selling a property, if typically there's a piece of real property involved in the probate, that does not have to wait. We can sell that and liquidate that asset before we do it during actually the probate.
Mm-hmm.
So we don't sell it at the end of the probate, right? The decision, we don't have to wait a year and a half to sell the property. So if you're a beneficiary, if you're an administrator, executor, the property can be sold. It gets sold at the initial stages once the letters and the probate order is issued, right? We can move forward that way.
Right.
Get it done. And then basically it leads into my next question is creditors claims, debits, things like that. When, for example, a single family residence or commercial, whatever the real property the estate owns, or whatever property there is, it goes through escrow. We close it out. The money goes into the probate account. And then for that point, I guess I would imagine creditors are notified of what the next process is for them to submit creditor claims, or do they do that? When is that? What happens there?
Before I get to your question, you said order and letters, and I just want to clarify. Or
Thank you, because I don't know.
And these terms are kind of kooky. So an order is just how it sounds. It's an order from the court in written form. what the court granted. Now, the letters is actually a one-page document. It's a very funky name, but it's called Letters of whether it's an administration, it's basically someone who did not have a will, or letters testamentary, which is someone who died with the will. That's the document that the personal representative needs to show to agencies that they have the authority to administer the estate. So, and yeah, you would think the order is the document, but no, it's actually the letters. But now back to your question with creditors' claims. What we try to do is, as soon as the individual is appointed, the administrator or the executor, and once we get the order and the letters, we try to start or send out notice to creditors immediately. Now, unsecured creditors, unsecured creditors, whether there are credit card bills or medical bills, if there's or if there's like an IRS or tax issue, that's a secured creditor. There's just no way around that. But with unsecured creditors, we would send out notice to all of them, and they have basically 4 months to come forward with a creditor's claim. After those 4 months, no one comes forward. The door's closed on them. They can't come back later and say, "Hey, the estate owed us however much money." The courts are very strict about that. It's like, "Hey, where were you 4 months ago? You were notified, and you never came, so you lost your opportunity." So with creditors' claims, they do need to file a creditor's claim, and then it's up to the personal representative to whether to accept, in other words, agree to the amount that is owed and pay it, or reject it. And if the personal representative rejects it, then the creditor has a choice of filing a civil complaint. It doesn't go through probate; it goes through civil. And then again, you can imagine it kind of goes off. It's another path. So a lot of times, even if it's like a minimal amount, the personal representative may just want to pay it. But unless they know for a fact it's not legitimate. Then completely understandable. So yeah, creditors could be a problem, but it's part of being an administrator. So another reason why you don't want to go through probate.
Yeah, it's you got to deal with that. And now, do you help administrators, or is there a situation where those claims are negotiated down? Do you help them negotiate? For example, if there's an American Express bill for $30,000 or something, do you help negotiate those to see if you can at least get those reduced?
Oh yeah, whenever we get a not a creditor's claim, but like a letter from the creditors stating that, hey, the estate owes us this amount, have it paid by yada yada yada. Once we present it to the client, the personal representative, I would reach out to the creditor and see if we could settle. And 9 times out of 10, they'll offer some kind of discount, because creditors, they don't want to go through the hassle. They understand too. A lot of times actually creditors don't even bother coming forward with their own claims. But again, there are some.
Yeah, and that's another reason why they should call you. Somebody going in pro per, they should call you if you have a lot of debt, because that'll at least save them a bunch of money.
Oh yeah,
it pays
couple
for itself.
hundred at the very least. Yeah,
it pays for itself working with a professional, right?
Yes,
I just people, nothing is free. You pay for quality, and that's the important thing, because you're going to be better off in the end, right?
I don't want to boast, but yeah.
So basically, going through probate or filing probate, should somebody go through probate? Should they even bother with it?
That's a good question. I guess here's an example. If a parent passes away, and let's just say there's only a mother, and the mother's divorced. I'm just going to keep it simple here. Let's say the mother passed away, divorced, so the father, there's no spouse, there's no partner. And let's say she had one kid, and it's an adult, and let's say it's a son. So the son now wants to. Let me make it even easier. Let's say the mom had no will, no trust, nothing. Okay, so now it's up to the son. All right, so a probate has to be opened, And once he starts digging into his mom's belongings, assets, whatever he can get his hands on, he realized, wow, there's a lot of creditors here. There's a lot of debts. And let's say the mom had a house, and let's say, again, let's keep it simple. Let's say the house is worth $1 million, but then let's say there's a huge mortgage on it. Let's say it's like over 900,000. It's like, okay, well, there's barely any equity. Okay. And then he starts looking further and he sees that, there's like a couple of dollars in a bank account. Okay. So needless to say, at the end, there's barely any assets in the estate, unfortunately. There's no point for the son to open a probate. I mean, unless he wants the couple of dollars and however much equity is in the house, but that may all be spent on statutory attorney's fees or whatever. So yeah, I mean, you really have to do a little bit of investigation and just kind of see, okay, what are the assets? Does it even have any equity, or does it have any funds? I mean, what I always like to tell clients are to just to prepare a spreadsheet, list all the assets, list their value, list all the debts and encumbrances or what have you, and then just kind of weigh the pros and cons and see, like, is it worth it? Should I even bother? We've had cases where someone would come forward and they'll tell us, like, oh yeah, my mom had over $1 million, but then she also had a ton of debt.
Oh, wow.
And then come to find out she never, like the last 10 years, she even bothered filing her tax returns. Like, ouch. Okay. Yeah. You may want to tread carefully here, So yeah, I mean, if the estate is worth practically of no value, there's no point. And what's going to happen to the estate? It's just going to sit there, and if there is a home, it's going to get foreclosed. And okay, I mean, it's not your problem. Sure. In other words, I get this question a lot, where going back to that mom and son example, the son would say something like, or would ask, hey, can the creditors come after me personally because, I'm her child? The answer is no, unless he signed some kind of liability agreement, or assigning himself to his mother's debts or what have you, which is slim and none half the time. And yeah, sometimes the creditors would come after the son and say, hey, you owe us money. It's like, no, you don't.
Gotcha.
But of course, they'll try to scare them and what have you, and it's despicable, but that's their rights, and the son just doesn't have to do anything. And if he gets any calls from creditors, what have you, just simply hang up or just tear the letter, and that's that.
Okay, interesting. Here's a question. If an estate has a certain value point, for example, it's over that threshold that you need to file, will the state of California, will they require those assets to go through probate? Is it a requirement, for example, if they have $500,000 in the bank and the property has enough equity in it, for example, the same, right? Is it a requirement that the state is going to say, okay, you didn't have a trust, you didn't have a will, you have to go through probate?
If I understand your question correctly, if there is a house that's worth about $500,000, yes, right away. If there are assets or personal property that's over $184,500, yes.
So there's no avoiding it, right? It has to be done. Is kind of what.
Because yeah, I mean, pretty much, yeah. So you can't avoid probate there. Sure. No, you really can't. Again, unless some of those other methods work, whether it's like a spousal property petition or a small estate affidavit. But again, a small estate affidavit, going back to that, that's not even bulletproof. That's not guaranteed either.
Sure.
Yeah. So again, more the reason not to go through probate or just have a trust.
Yeah, it's simple, easy fix, right?
Yeah, or unless when you pass away, have no assets on you.
That's even better way. Yeah, go out owing. That's what I want to do. Go out owing. And when somebody's in probate, does it ever get contested?
That's a good question. Yes. Now, not always, but yes. Going back to those, that case you brought up, Eric, with the 3 administrators. Now, I don't know the case exactly, but let's say they are the three children, so they're siblings, and let's say one of them disagrees with the other 2 even before they get appointed. But now, of course, if one of them disagrees with the decision making, all three of them have priority. What that means is all three of them stand a chance to become the administrator. So if one disagrees, for example, let's say there's, just to keep it simple, let's say there's Arthur, Beth, and Kurt, and let's say Arthur wants to be the administrator, Beth is on board, but Kurt is not. Okay, well then basically it's the two siblings against the one sibling, and then that's only gonna prolong the process, and that could be litigated potentially. Now, in those situations, courts just tend to appoint a fiduciary or someone who does this for a living, someone that's licensed in the state and will know the probate process and will just get it done. Will act neutrally and it'll be done with it. Now, yes, there's a cost. It is a job, but you know what?
Sure.
It's better than going back and forth and getting it litigated and all that stuff. So that's like kind of the best example I can give. But yeah, there's also beneficiaries who can dispute it, or go up against one another, and that will also prolong the matter. So yeah, there are so many ways to have litigation in a probate process.
So the key is to get along, right? Otherwise, it will cost everyone money.
What I like to say is get everyone together, sit down at a table, and just talk it out.
Sure, yeah.
If you guys can come to some kind of agreement, it's going to save everyone tons of money, tons of stress, and it's just, really, like, let's say if it was the mom who passed away, and then again, going back to the three children, in the end, the mom didn't want the three children to duke it out.
Sure, yeah.
She just wants to provide for the three children.
Yeah.
Hopefully. So, yeah.
It's kind of interesting, I'm in those situations where, I see it a lot where, you'll have different beneficiaries. You could have multiple administrators, and someone will decide to use their sister from church or their family member for the real estate transaction. And they'll end up just kind of dealing with one administrator as opposed to the other one, or the beneficiaries. And they try to communicate what they're doing or what their goal is to one administrator. And if they're trying to share that, a lot of times they're going to need to share that with other beneficiaries, because they can object to that sale, right? If you're going to renovate the property or sell it for a certain price, the other beneficiaries can object through the notice of proposed action.
Exactly. Yeah.
So it's good to have
very important too.
Oh,
yeah.
And people don't get it. They just you have to know the process, because not only the additional forums to sell real property, but how to communicate to the beneficiaries, and that's going to be the key. Like when I do something, I'll create a video walkthrough of why we do things, and it could be 20 minutes long, but it's something that everyone can see. So it's not, it's not the telephone game going from me to them, to them, to them, and everything changes, right? So everybody sees exactly what's going on all at once. So it's a huge benefit, and everybody understands what's going on. The beneficiaries call me. So, working with an agent, having somebody and being able to work with the attorney, because that's important. And a lot of times, I'm sure you see that where, the agent doesn't communicate, that they have an offer accepted. So the NOPA gets delayed, and there's the waiting period, escrow gets pushed off, or the buyer's rate locks expires. And there's all these issues of making sure that you need to keep your eye on everything, because the smallest little thing could have rates, nowadays going up.
Yep.
A lot happens. So, working understands probably understand how to work with the attorney and what they need is really important, because it could be a nice costs a lot if you don't.
Yeah, it does. Whether it's you and I working together, try to minimize much of the problems as possible. Now, fall through the cracks, but or doesn't have an experienced realtor, things could spiral.
Well, I really being on the Probate Café. Thank you for joining us.
Thanks,
and get everybody where you work and kind of your specialty.
Again, my name is Weily Yang, Weily Coyote. I am with Mortensen Reinheimer. Fine. It's been a real pleasure. Never done a. This has been a lot of fun. So thanks, Eric.
You're welcome. Thanks for joining us. And guys, stay tuned for the next episode. You're going to learn a lot. If you're reach out to and or myself, we'll get you taken care of and connected with the right attorney for whatever services you need.